Thank you, Mr. Chair. Members of the committee, Senate Bill 73 addresses a gap in Colorado's family law system that leaves parents and children permanently separated from time that can never be recovered. When Child Protective Services or law enforcement investigates allegations of abuse or neglect in Colorado, parenting time is often immediately suspended or restricted, a necessary precaution to protect children. But Colorado law currently provides no mechanism to restore that lost time when the investigations conclude with no findings. During investigations, families may face significant disruptions, including supervised visitation requirements, even when allegations ultimately prove baseless. Yet, unlike many aspects of family law where courts can modify orders or to reflect changed circumstances, there's no corresponding provision to restore wrongfully denied parenting time. The current approach essentially tells cleared parents, the state investigated you, found you did nothing wrong, but you permanently lose that time with your child anyway. For parent-child relationships, that time is irreplaceable. A toddler's developmental milestones, a child's birthday, a teenager's graduation, those moments don't repeat. When investigations prove unfounded, shouldn't our law also include a pathway to restore what was wrongfully taken? Senate Bill 73 provides that remedy. It requires courts to order additional parenting time of the same type and duration as what was wrongfully denied when investigations conclude without findings of abuse or neglect. The bill includes appropriate judicial discretion through a good cause exception and limits make-up time to a 2-year window. It explicitly does not create liability for state agencies conducting necessary investigations. This is about fairness. It's about recognizing that when the system makes a mistake, when it restricts a parent's time based on allegations that prove unfounded, that parent and child deserve an opportunity to recover what's lost. I've heard caution that we don't want to put kids in the middle of a dispute with this bill, and my take is that kids were placed in the middle when they were taken under false testimony in the first place. This bill rights that wrong. This is about accountability, it's about fairness, and it's about common sense. And it's about recognizing that parental rights matter, that family time matters, and that when the state disrupts those bonds without justification, we have an obligation to make it right. I urge the committee to support Senate Bill 73 and send a clear message that in Colorado, when parents are investigated and cleared, they don't just get their rights back, they get their time back too. Thank you. Happy to answer questions.
Okay. Members, are there opening questions of Senator Bright's? Senator Henriksen.
Thank you, Mr. Chair, and thank you to the good senator from,
Platteville.
Weld County? Wait, Platteville. She's in Weld County, right?
Yeah.
As I read this and as I understand your comments, I think what I am understanding is there is a concern of parents have a dispute. There may be circumstances where a parent weaponizes dispute, disagreement, or general hurt feelings to pursue a frivolous claim against the other parent. And while that claim is investigated, the parent who is the accused loses the parenting time. And then, if it's unfounded, they've lost that time. They never get that back. And I can understand the concern of a safeguard against that. What immediately comes to my mind, on the flip side of that I would worry about as a balancing is, let's say that I have concerns as a parent who's, let's just say, I'm a parent who's divorced or separated. I have concerns that my kids have described to me. I don't know how valid they are. Kids, aren't always the most accurate, but they weren't a concern. Would this bill does this bill risk silencing me from raising those concerns? Because I don't want to see, example one, a frivolous claim that results in a parent losing their time with the child, but I also don't want to see a parent who is concerned and doesn't, is maybe not fully sure of those concerns, but that's all very valid, feeling like they should withhold that would also be very bad and potentially very dangerous for a child. And so trying to balance those two, and so I guess I'm wondering, is there a system now in place that allows for consideration of both ends of that teeter-totter, so to speak?
Senator Bright.
Thank you, Mr. Chair, and thank you, Senator Henriksen, for the question. I think the beauty of this bill is that it does provide that balance. Right now, there's not an imbalance in the system, whereas the allegations can go in any direction and are never provided that check. And so I feel like this bill would provide a provision that would make sure that the content of the allegation is accurate. Oftentimes it's used in inaccurate ways. And so this bill would provide that second double check just to make sure that it is accurate. And this is to extend into those few times when the system is used against the other parent.
Senator Goodfriend now. Follow up.
I may have more questions during testimony, but I think that lays the foundation of how I'm trying to approach this and understand it.
And members, there are a pretty good number of witnesses signed up on multiple positions, so we'll be able to get into that shortly. Committee, other questions for our sponsor? Senator Bright, I do have one. To the threshold contention that where there's a complaint, it goes to County Human Services. It's, for whatever reason, maybe we'll get into this, did not result in a finding of abuse or neglect. There's no mechanism. 1410-129, modification of parenting time, existing law, provides that the court may make or modify an order granting or denying parenting time rights whenever such order or modification would serve the best interest of the child. So deliberately very broad, as family law tends to be revolving around the best interest of the child standard. I guess my question for you, and maybe witnesses can get into this too, why is that not sufficient to address the fact patterns that we're talking about here?
Thank you for the question, Mr. Chair, and I do believe our witnesses can expound on that better. The reason that this is coming forward is because it has been a problem, and so we're hoping to address the problem and provide a fix with this.
Okay. I may pursue that later. All right, members, last call for questions of Senator Bright. Seeing none, we'll go to witnesses. All right, Senator, we've got about one panel of against and amend, a couple of for. How would you like to start, and then we'll just alternate?
Start with oppose, then amend, then for.
Okay. If you don't mind, I'll just for efficiency, I'll combine oppose and amend. And then we'll go to for, like you said. In person, we have David Carnes. And then signed up online, we have Courtney Sutton, Elizabeth Newman, and I think in person, indicating an amend position, is Grisel Lopez. And I believe that when we get there, Ms. Lopez will be communicating with us in Spanish. And members, we've had once before, we have interpretation services via the earpiece. But we'll start with Mr. Carnes. Please go ahead.
Chair and members of the committee, thank you for the opportunity to testify. My name is David Carnes, and I'm a public policy specialist at Violence Free Colorado, the state's anti-domestic violence coalition. I'm here today in opposition to SB 2673. I'd also like to note that the Colorado Organization for Victim Assistance had planned to testify today but was unable to attend, and they asked that their opposition to this bill be included in the record. This bill creates a mandatory make-up parenting time rule. If parenting time is denied during a law enforcement or child welfare investigation and there's no abuse or neglect finding, the court must award extra time unless good cause is shown, and the denied parent can select the dates. That structure can be exploited to destabilize routines, escalate conflict, and keep survivors and children tethered to ongoing manipulation, and it can discourage good faith reporting when families fear they will be penalized for raising safety concerns. At its core, domestic violence and coercive control rarely fit neatly into what a system can document or prove on a short timeline. Investigations can end without a finding for many reasons that have nothing to do with child safety. A lack of substantiation is not the same as a determination that the child is safe, that coercion is absent, or that the risk is past. I also want to address a narrative that often surfaces in discussions such as this. Sometimes we hear that our opposition to this bill is rooted as a gender issue or implied that we're biased against fathers. That is not who we are. Our goal at Violence Free Colorado is to see all survivors receive the dignity, support, and justice they deserve regardless of gender. We also need to be firm about the frequently cited concern of false reporting. False reporting is extremely rare. Additionally, any suggestion that Violence Free Colorado or our members condone knowingly untrue allegations is categorically false and deeply offensive. According to data from the U.S. Department of Health and Human Services, intentionally false reports are believed to make up less than 1/3 of official dispositions. And for domestic violence, while there is not one clean national statistic across systems, it's crucial to remember that unproven is not the same as false, and the narrative that false DV allegations are common is not supported by credible evidence. Colorado can address parenting time interference without creating incentives that punish protective parenting, discourage help seeking, or create new tools for coercive control. For these reasons, we, Violence Free Colorado and the Colorado Organization for Victim Assistance, respectfully urge a no vote. Thank you.
Okay, thank you. Did we have Ms. Lopez as well? Okay, please come up. Señor, usted puede decir cualquiera en español y entonces el señor va a traducir. And Ms. Crowdy, do we have Ms. Newman online or did we lose her? Okay. Por favor. I'm sorry, disculpe, usted tiene que usar el micrófono. Okay.
Gracias, miembros del comité. Mi nombre es Grisel López. Estoy aquí como madre sobreviviente de violencia doméstica. Estoy aquí porque mis hijos perdieron años de su vida conmigo. No por abuso, no por negligencia, sino por demoras y fallas del sistema. Este proyecto de ley es importante porque reconoce una verdad sencilla. Cuando el tiempo de crianza se retira durante una investigación y esa investigación no encuentra abuso ni negligencia, los niños no deberían perder a uno de sus padres de manera permanente. Estamos hablando de hallazgos reales, no de suposiciones, no de triangulación, no de manipulación emocional, ni de las consecuencias de control coercivo o de acusaciones exageradas que nunca fueron comprobadas. En mi caso, después de que mi abusador fue arrestado en Inglaterra en enero de 2024, se trajo a nuestros hijos a los Estados Unidos sin mi conocimiento y yo no sabía dónde estaban. Yo era la mamá cuidadora principal de ellos y de repente fui borrada de sus vidas. Durante casi un año mi caso no fue escuchado, no había investigaciones abiertas, no había ninguna razón para mantener a mis hijos lejos de mí y aún así los perdí. Para cuando el tribunal intervino, el daño ya estaba hecho. Mis hijos habían sido condicionados emocionalmente. Hoy, incluso con custodia compartida, no he tenido contacto con mi hijo por 2 años. Veo a mi hija solo algunas veces sin poder tenerla conmigo por las noches. SB 26073 no puede reparar lo que le ocurrió a mi familia, pero sí puede proteger a otros niños para que no pierdan un tiempo que jamás podrían recuperar. Esto no se trata de padres peleando, no se trata de la política ni de qué partido patrocinó esta ley. Esto se trata de niños pagando el precio cuando el sistema falla en actuar. Por favor, les pido que apoyen SB 26073 para que ningún niño más pierda a un padre amoroso por el silencio y la demora y la inacción. Gracias.
Okay, gracias. Sir, thank you for translating for us. All right, members, questions for either witness? Mr. Carnes, just to clarify, so we had Ms. Sutton signed up. She wasn't able to make it. It's been a long afternoon here. Sounds like you've communicated you are authorized to say on behalf of COVA that they have a position of opposition as well. Okay. I'm trying to think how to frame the question, and I don't know how deeply you get into these things in your work with the organization, but I think a key question here is what are some circumstances, understanding that these, I mean, I guess I agree with Senator Bright in his initial comments to the extent that the kids are already dragged in here. I mean, these things are messy and horrible. I think we've all seen that over years in this legislature. But where a situation does go to County Human Services, what in your experience are some reasons why there might not be ultimately a finding? And then given that, why might what the bill seeks is sort of at least a heavy presumption of time being awarded, why might that not be appropriate?
Mr. Chair, thank you. So to the first part of your question, for example, some of the challenges in investigating this, whether this be child welfare, whether this be criminal investigation, is that a lot of elements of abuse are not quantifiable or measurable. So things like coercive control is not, you can't measure that. Things like gaslighting, things like emotional abuse are very hard to quantify and very hard to prove. That does not mean that those elements are not there. It just means that what current standards are as far as what someone can be charged with, that those standards may not be met in those situations. As to the second part, our primary concern is the language of the bill that states that the party who's being restored parenting time is allowed to pick the dates and times to make that choice. That is a very clear way that someone could exert coercive control over someone, could be disruptive to a schedule, or just otherwise cause problems for a survivor in that situation.
Okay, appreciate that. One more question, acknowledging it's pretty in the weeds. I don't know if your experience is taking you here. The other statute that I mentioned, 1410-129, the generally applicable ability for either parent to seek an adjustment of parenting time where it's in the best interest, which is, I think, deliberately broad, able to be utilized, at least as a threshold matter, by either parent. That is or is not sufficient in your view. Why?
Thank you, Mr. Chair. I would say that our current system has a lot of flaws in the ways that judicial discretion might be used when it comes to the standard of proof. That tends to be the biggest problem that we see with that. I do think I would be in complete support of both parties being able to raise those concerns. I do understand that litigation abuse is absolutely a part of an extension of coercive control that can be used by either party. They are very complex, as you're saying. I am not an expert on the custody process, but that tends to be the concern.
Thank you. Members, other questions for either witness? All right, seeing none, we'll let you off the hook. Thank you. Gracias. Okay, I will start calling folks who signed up in a supportive position. Given the hour, I'm going to first call folks who are signed up indicating in person so that they can be on their way after testifying if they would like. Carl Roberts, Crystal Richmond, Ashley Posey, Myron Campbell. All right, thank you all for being with us as we work through prior bills. We'll just start at this end. Ma'am, please go ahead. Let us know your name, organizational affiliation, if any. Please proceed. Please make sure the mic's on. It's the gray button on the stem.
My name is Ashley Posey, and I'm here for representing myself. Thank you for hearing me today, committee. May of 2024, our family experienced a loss I never knew was possible. My granddaughter was taken by her mother without notice or warning, and since then we have been consistently fighting an uphill battle with very limited access to have her home and no accountability for her proven false allegations. We spent 219 days unable to see my granddaughter, hold her, or even know how she was doing. Not being with your child or grandchild is an invisible grief, but it's a very real one. When the child's mother refused all contact, my son filed an allocation of parental rights. He never sought sole custody. He only wanted to remain involved. Immediately after filing, the mother responded by filing a false temporary order using the commonly known tactic of the silver bullet. With help from her mother and misuse of professional connections, the TPO was filed in a county where neither the mother nor the child lived. This created a separate legal battle, significant expense, and great emotional harm. She never appeared in court and faced no consequences for filing this claim. Despite blatant lies and falsehoods presented, these claims were accepted without investigation. Although the judge verbally acknowledged my son's desire for involvement, the final ruling didn't fit that acknowledgement. As a result, our family lost irreplaceable time with a child we loved deeply, and that loss continues today. Childhood does not pause while courts delay or rely on unproven allegations. We need reform. Time taken over false allegations should be given back to a fit parent when those claims are found to be false. Allegations alone should never be enough to remove a parent or family from a child's life when they are fit and able. Children deserve better, families deserve fairness, and no parent or grandparent should ever have to endure the loss of being in a child's life. Thank you.
Okay, thank you. Mr. Roberts, please go ahead.
Thank you, Mr. Chairman. My name is Carl Roberts, and I am in support of 26073. Family court and CPS are both severely broken, causing far more harm than good to children and parents alike. They are systems that profit by pitting parents against one another, where children are abused and manipulated as weapons, pawns, and prizes. Family court is an equal opportunity arena for moms and dads to have their lives and families destroyed. That the one fact that courts, CPS, and this legislature refuse to acknowledge and address is that all parents in contested custody have a motivation to lie about the other. Not every parent acts on that motivation, but far more do than don't. False allegations are standard practice in almost every case. False allegations are coercive control and the most pervasive form of domestic violence that systems and policy makers ignore and excuse. Tightly intertwined is parental alienation, which is the most pervasive form of child abuse in contested custody. And a false allegation is the primary weapon for parents to alienate the other. Yet Colorado's legislature, CPS, and family courts are seemingly indifferent to the most pervasive forms of domestic violence and child abuse. Why? Because policymakers have been misled by anti-father groups who oppose this bill. Violence Free Colorado, along with others who are testifying today, promotes falsehoods about domestic violence. They want lawmakers to believe that DV is gendered in only one way, that false allegations are rare, they are not, and that parental alienation is not real. It's very real. They are not advocating to protect women or children. They are advocating for three things: for courts to presume the accused are guilty, to protect their primary strategy to deny a child a loving parent, and to avoid accountability for making a false allegation. They mislead you so that you believe that any steps to curb false allegations will discourage people from making true reports of abuse or violence. They lie. They aren't trying to protect women and children. They are protecting their ability to deny a child a loving parent if they don't want them around anymore. Thank you I ask you for your yes vote. Open to any questions.
All right, thank you. Mr. Roberts, I'll let you finish your commentary, but for the sake of the rest of the hearing, testimony about your own opinions is allowed. Testimony about your own experiences is allowed. We're not going to have any testimony that gets into characterizing other people and what they have said. We speak to the policy. We do not speak to personalities. I'll leave it there. Please go ahead, ma'am.
Chair and members of the committee, thank you for the opportunity to speak today. My name is Crystal Richmond. I am a DV survivor and a member of El Paso County. I am here in support of Senate Bill 2673. Today, instead of summarizing my story, I want to read a few brief excerpts from messages that were sent to my husband's child during a period of severe alienation. Please excuse some of the language. She was just 12 years old at the time this was said to her. Remember, I told you, You need to record all of these conversations. If dad continues to try and talk to you, you need to tell them. You will always choose to not have as much to do with him as you can. And the more he forces you, the farther you will run. Fuck dad, fuck all of them. Stand your ground. Tell them, no, you're not doing anything. You are allowed to do that. If he tries to go to the hospital, you can tell the staff that you don't want him back with you. Then tell them that you're not suicidal. I love you. Please make sure to delete everything all the time. Delete, delete. These were not isolated comments. They were sustained pressure to reject her father and withdraw from our home and family, including her grandparents, who were very close with her. She suffered a severe mental health crisis, including suicidal and homicidal ideation. She was hospitalized for months, and although my husband was later granted full custody and now shares equal parenting time, the time that was taken was never fully returned. The trust and attachment that were fractured have never fully recovered. We have not heard, "I love you," or have received a hug in nearly 3 years. SB 2673 matters because when parenting time is wrongfully denied and no abuse or neglect is substantiated, there is no meaningful remedy for the lost time. This bill does not override child safety. What it does is require courts to restore equivalent parenting time when it is wrongfully denied. When time is taken from a parent and a child without justification, it should not simply be erased. There must be a mechanism to try to repair what damage has been done. I urge you to support Bill 2673. Thank you for your time.
Thank you. Mr. Campbell, please go ahead.
Thank you. My name is Myron Campbell, and I'm here to support the SB 26073. This bill is about something very simple. If time is taken and allegations are not proven, that time must be returned. That's it. When the parents deny the court-ordered parenting time because of investigation, and that investigation finds no abuse, no neglect, what happens? Right now in Colorado, nothing. But at the time, let me see. Right now, I've got nothing. The time's gone. But that time doesn't disappear on paper. It disappears from a child's memory. It disappears from the birthdays, from the weekends, from the holidays, from ordinary moments that builds attachments. And here's the problem. An allegation alone can interrupt parenting time, but even when the allegations are unsubstantiated, there is no automatic repair. SB 26073 creates that repair. It says if the system intervenes and the parent is cleared, the court shall restore that time. Weekends for weekends, holiday for holidays, vacation for vacations. Not as punishments, not as leverage, but as restoration. This bill protects children from unnecessary disruptions. It discourages weaponizing allegations, and it and it reforms, and it interferes something fundamental. Sorry, y'all. Court orders parenting time is not optional. It is child rights to both parents. Texas passed this, North Dakota passed it, and over 25 states are considering it. This should not be controversial. If there's no damage, protect the child. But if there is no findings of abuse or neglect, the child should not permanently lose time of a loving parent. Time taken, time back. Simple, fair. I urge you to support SB 26073. Thank y'all.
Thank you. Committee questions for any of our witnesses? Mr. Vice Chair.
Thank you, Mr. Chair. Thank you all for being here and sharing your testimony. This could be for whoever wants to answer, but maybe Mr. Roberts. The term on page 2, the term wrongfully denied, I'm curious if that has any other meaning in case law or in statute. It seems to be could be a very subjective standard based on who the judge is. And I'm just wondering how, in practicality, a judge would decide whether parent or legal custodian parenting time was wrongfully denied.
Mr. Roberts.
Thank you, Senator. As you know, broad discretion in family court It's all subjective. There's no evidence one way or another required. No preponderance of evidence is really not required. No due process is required. Judges can make up their own rules. They can see very valid evidence of abuse and harm and dismiss it because it doesn't fit the narrative that they want to believe. They can also take the most frivolous of allegations and accept it as fact because it fits the narrative they want to believe. So, again, I'd have a hard time kind of saying wrongfully denied. Basically, in the context here is you were accused of doing something. It wasn't founded that you did something. And then, again, the opposition may argue about, oh, it's too hard to prove this, that, or the other. But being unfounded, I mean, we're talking about the child. We know for a fact, you know for a fact, that children are put in the middle here, that they are weaponized. Systems are weaponized through false allegations, which are as common as the hairs on your head. Not my head, but more common than the hairs on my head. It's every day, in every county, in every case, when it's contested custody. Contested custody is not about the child or the safety of the child. It is about money, power, and control. The single difference between a contested and uncontested custody is simply the presence of a bad actor. That bad actor is one or both, man or woman, quite frankly, lawyer or litigant. And when either one of those, when a bad actor enters the picture, this all spirals out of control. And it's not about the child. It's about power and control. It's about the narcissist.
Thank you. Members, other questions of this panel? Senator Frizzell.
Thank you, Mr. Chair. My question's for Mr. Roberts. You made some very bold statements about Child Protective Services, CPS. And do you have any actual data to back that up? Do you have any information that is concrete?
Mr. Roberts.
Thank you, Senator. Yeah, I pulled the data from CPS's website, CDHS's website for 2024. And of the 120,000 calls that are coming into the hotline every year, roughly only about 3.5% of those calls, 4,200 of those, are ultimately substantiated and founded, right? And so they go through a kind of a washing of those things. I forget what the number is, but something like 52% of the calls go into kind of a high-risk assessment. And so of those high-risk assessments, 90% of those that get flagged as a physical abuse, they come back as unsubstantiated. So disagreeing with the other testifier earlier, again, you can't prove again, the coercive control and the emotional abuse, and I completely get it. But those are a far smaller number of those cases. And even in those cases, only about 80% of those only about 20% of those that come back as founded. But the physical abuse, and again, just the investigation alone, that trauma, they can take 2, 3, 4 months and comes back with nothing. And then the opposition may say, well, they just couldn't prove it. Okay, come back when you can. And again, to the fallacy of the argument of saying that having any curb on false allegations or any accountability on false allegations is a hindrance to true allegations, to real stuff, real violence, real abuse. The most polite word I can have for you is just a falsehood.
Members, other questions? Seeing none, thank you all for being with us this afternoon.
Thank you, Senators.
All right. I'm going to keep calling folks who signed up indicating in-person presence. Do we have Ryan Shelton? John Hopper? Nancy Regan? And Robert Garza? Okay, apologies. I think Mr. Garza is actually online, but let's add him if we can. Anyone else in the room wanted to testify to Senate Bill 73, any position? Okay, let's keep adding a few more folks online. Do we have Rosemary Van Gorder? Eric Liber, Liber. Christopher West. Judy Atwood. I'll just call the rest of the names. Lily Landakusik, Deborah Randall, and Melanie Jordan. And while folks are getting connected, we'll start in the room. Ma'am, please go ahead.
Am I on? Okay. Honorable Chair and members of the Judiciary Committee, thank you. My name is Nancy Reagan. I'm a mother of Colorado and a survivor of domestic violence, and I respectfully urge you to support SB 73 as I do. The issue before this committee is whether Colorado courts should have clear statutory authority to restore parenting time when a parent is wrongfully denied court-ordered access based on allegations that are later determined unsubstantiated. When time is wrongfully lost, the harm is immediate and often irreversible. The rule, SB 73 authorizes court to award equivalent make-up parenting time when a parent is denied court-ordered time and an investigation by child welfare or law enforcement results in no substantiated findings or abuse or neglect. The bill permits the restoration of equivalent time, such as weekends or holidays, within 2 years, and that is statutorily different from 14-129, in which case all missed make-up time has to be made up within 6 months. It simply creates a corrective mechanism where one is currently unclear or insufficient, as this is, as it stands. In my analysis, in my case, allegations were raised and investigated. There was no substantiated findings of abuse or neglect. Nonetheless, my children were relocated. The litigation continued for an additional 20 months after relocation, and by the time the matter was resolved, meaningful restoration of parenting time was functionally not possible. The financial costs have exceeded over $350,000. The emotional cost to my children cannot really be quantified. This problem is broader than my experience, though. A 2023 published study in Children and Youth Services Review examined 492 U.S. custody decisions involving parental alienation claims, and of 654 investigated, 70.6% were unsubstantiated or unfounded, 10% were substantiated. While unsubstantiated does not mean false, such allegations frequently affect custody determinations and parenting time outcomes. Absent a statutory remedy, time lost under unsubstantiated investigations is rarely restored. SB 73 addresses that gap. It promotes accountability while maintaining child safety. It protects the integrity of the courts. It reduces unnecessary litigation by providing a defined path for relief. Most importantly, it safeguards children's ability to maintain stable relationships with both parents when no abuse is substantiated. Parenting time is not theoretical, it is finite. Once lost, it cannot be recreated, only restored if the court is empowered to do so. SB 73 provides a measured balance remedy that supports judicial efficiency, fairness, and child-centered outcomes. For these reasons, I respectfully ask you for a favorable vote on this bill.
Thank you. Sir, please go ahead.
Ryan Shelton, Littleton. Thank you, Chair. Thank you, Committee. 1 week ago, I sat in this exact room for 5.5 hours, listening to parents tell deeply personal stories, different backgrounds, different politics, different circumstances. But the same theme. Families entered family court looking for protection and left with more damage. What struck me walking out of this room was the system, the very system designed to protect our children and endure due process, is broken. Malcolm Gladwell, author, journalist, describes a tipping point in culture. That percentage is around 25 to 30% from his analysis, when a system reaches a moment of necessary change. Today, 25 states are considering this very same reform. Texas and North Dakota have already passed this bill. This is not coincidence. It's a signal. This bill is simple. When false allegations are made in custody disputes, an emphasis in custody disputes, courts must address that injustice. In my case, I am now 555 days without my children. There were 11 CPS allegations, 2 separate 911 calls, all investigated, all 100% unfounded. CFI concluded unfounded. PRE concluded unfounded. Law enforcement concluded no abuse. CPS documented in their final report, children were safe in my home, and said that they were not going to respond anymore to allegations, and explained that this was because it was deemed a family conflict issue, and the kids were not being abused in my home. Restriction preceded fact, and that fact has not tilted yet, although it is very present in our case. Therapy alone for my children, $24,000 and rising. Reintegration for false allegations. We got on the one-way on-ramp and have not been able to get off since. This bill restricts that from happening. The real cost is the measure in lost time, birthdays, school events, and daily life. This is the most crucial piece, and it's a nuance in the data. It is important to distinguish between allegations during a custody battle versus not. False allegations under non-conflict conditions remain between 14 and 12%, or 4 and 12%, drastically changing under conditions of court. BALA, allegations of child abuse in contact of parental separation, 40 to 50, unsubstantiated. Track me, false allegations of abuse and neglect when parents separate, 30 to 60% unfounded. U.S. child welfare data, U.S. Department of Health and Human Services annual 2022 published data, January 24th of 2024, 75 to 85, unsubstantiated. And here's the key, in custody battle. As a published researcher in top-tier reviewed publications such as the American Journal of Emergency Medicine, the key is how you interpret the data. The facts are there. High conflict exponentially increased false reporting as a strategy, frequently with mental illness as a driver. That is legal abuse. That is coercive control. That is what we're trying to fight against. It's a loophole that must be closed, and this bill does just that. This is not punishing parents. It is protecting children from being weaponized in high conflict divorces. It is avoiding them being placed as a pawn. Divorce is between adults. Children deserve stability, not strategic litigation. This is important. When courts fail to address false allegations, children are turned into a leverage. This bill restores parental accountability, protects due process, and protects the children from becoming pawns. Please vote yes.
Thank you. Please both remain there. We'll go to our online witnesses, then we'll invite questions. Mr. Garza, please go ahead.
Thank you, Chair and members of the committee. My name is Robert Garza. I'm Vice President for National Family Justice. This same bill passed unanimously in Texas with bipartisan support and was signed into law by the governor. North Dakota has since passed it, and they did double the time back. Texas did time back. I am here because across the country, court orders are being ignored, parents are being wrongfully accused, court-ordered parenting time is being denied, and our children are paying the price. When a parent is wrongfully accused and denied court-ordered parenting time without a finding of abuse or neglect, the harm is real. Birthdays are missed, holidays disappear, summers never come back, and they are abstract losses. These are moments of a child's life that cannot be recreated. And in most states, there is no automatic remedy. This bill is simple and rooted in due process. If a court finds there was a wrongful denial and no finding of abuse or neglect, the court shall return the same type of time and the amount of time taken. Not extra time, not bonus time, the same time. If a holiday was taken, the holiday is restored. If a weekend is denied, the weekend is replaced. If summer was interfered with, then summer is returned. Once wrongful denial is established, the burden shifts to the denying party to prove why that time should not be returned and given an opportunity to justify their actions. But if they cannot meet that burden, the time shall be restored. This strengthens judicial authority because without enforceability, court orders become suggestions. If you believe our child protection services are overwhelmed, then you should pass this bill by removing the incentive to weaponize accusations for leverage in custody disputes. This law helps return limited investigative resources to child protective services, law enforcement, district attorney's offices, and the family court system so they can focus on children who are truly being harmed. If there is a failure within the CPS system, that failure should be addressed directly with them, but not this bill. This bill is not the problem. This bill restores accountability. I personally endured more than 43 false allegations, spent over $700,000 fighting to remain in my children's life as a fit, willing, and able parent. Perjury is rarely prosecuted. That vacuum is where the weaponization thrives. We cannot have a strong nation without strong families, and we cannot have strong families if court orders can be ignored without consequence. You cannot give a child back a lost birthday, but you can send a very clear message that time stolen will not stand. Time taken must be time returned. I respectfully urge you to pass this bill.
All right, thank you. I'm just going to move around the screen in the order that folks are showing up here. Christopher West, please go ahead.
Hello, my name is Christopher West. I'm a father of 2 children in Colorado. I'm a 21-year educator with 14 years in Colorado, and I am here to support of Senate Bill 26-073. This bill addresses a critical gap in our system. When allegations trigger investigations, parenting time is often restricted or suspended. That can be appropriate while safety is being assessed, but when those investigations do not result in a finding of abuse or neglect, there is currently no automatic mechanism to restore the parenting time that was lost. I have experienced this firsthand. In my case, allegations led to a protective order and criminal charges that were later resolved without findings of abuse or neglect. During that time, I lost significant parenting time with my daughter, who just turned 10, and I have had extended separation from my son, who just turned 12. I requested a PRE, a parental responsibility evaluator. I paid approximately $6,000 for this, and over $14,000 for independent third-party evaluations to investigate concerns in my case. However, due to the structure of the current law, including limitations related to cadence law, certain information from those evaluations could not be considered in any way that I'd hoped. While a protective order was in place, I followed it strictly. I used third-party witness parenting exchange. In one instance, a neutral witness observed and confirmed that the exchange was peaceful. Despite that, additional allegations resulted in law enforcement responding to my residence. I share this not to criticize any agency, but to illustrate how easily parenting time can be lost due to this process, even when abuse is not substantiated. In my situation, key witnesses were present. Those charges contributed to 9 weeks of lost parenting time with my daughter. Even after matters were resolved, the time was not restored. Birthdays, school events, ordinary moments, those moments do not come back. This bill does something narrow and fair. If parenting time was wrongfully denied due to an investigation that does not show neglect or abuse, the court must compensate that lost time. It does not punish agencies. It does not create lawsuits. It does not change custody standards. It simply recognizes that time with children matter. When a parent is cleared, the relationship should remain permanently reducing without remedy. Children benefit from meaningful relationships with both parents when it is safe. Senate Bill 26-073 creates a balance. Supervised path to restoration. I respectfully ask for your support. Thank you.
All right, thank you. Please hold on the Zoom until we've heard from all witnesses, then we'll go to questions. Looks like Ms. Linda Cusick is connected, but maybe not promoted. We can see she's got a hand raised there. We can promote her and we'll come to her for testimony in a minute. But let's go to Deborah Randall.
Hi, my name is Deborah Randall. I live in Colorado Springs. I'm the grandmother, so I appreciate the grandmothers talking. I thank the committee for their time, for the effort that you put into looking at both sides of the coin and listening to all of us. It's a collective burden to bring all this information to you and have you sort through it. What this bill does is it gives my son time back with all his false allegations. You asked about the influence of 1410-129. It's a little more difficult to go into court when you don't have clear authority to say, here's the black and white of what happened, and I'd like my time back. Everything else, when you go into court, in family court, and I'll say this till the day I die, when we started this process, we thought justice reigned. It does not. He who can speak the best wins. And it's an unfortunate way for family court to be run, but it's true. So what this bill does is it makes it simple, and it's all my colleagues have said. You go in, you make your statement, you do your motion, and you're done. You don't have to go through months and months and months of litigation. The committee should be aware that currently in El Paso County, there's an open appeal for false sexual allegations against a father who lost custody of his kids. False allegations. It happens. You should also be aware that I put a link in the chat that talked about statistics that you asked about. That was from the Heritage Foundation. So it's a 2023 report. But it gives you an idea of the level of false allegations that currently occur. So what I can tell you is that I'm living it. It is a day-to-day thing right now. This is our second CPS report. The first one was in Nevada. We had a wonderful CPS guy. He walked in and understood that they were false. But here's something that someone has not said yet. She was coercing the children to make false statements. Imagine a mother making her children make false statements. And here we are again. In the last month, we are now fighting this battle again. And when this battle gets won, which it will, because I want you to know that now what we have to do, just like the other father, he has to have witnesses around. We're not around the children without multiple adult witnesses who can provide context and meaning and say, hey, here's what happened. So we have children who are growing up coerced by their mother to say things. And I just want to say one last thing, if you give me just another second. My son came to me in the last few days and he said, Mom, it's like watching someone drown your kid and not being able to do anything about it. Those are true facts. They're false allegations. And when this is done, he needs to have his time back. That child is damaged and needs to bond with his dad again. Thank you for your time.
All right, thank you. Mr. Leiber, please go ahead.
Yes. Hi, good evening. My name is Eric Lieber. I stand in support of SB 26073. This bill would have prevented my relationship with my daughter from being completely severed and hopefully save many kids from this abuse in the future. 13 years ago, my daughter was born in Denver, Colorado, and against what I thought was best for our daughter, her mom moved her to Grand Junction, Colorado shortly after she was born. After realizing that co-parenting was going to be difficult, in 2013, I filed a motion to set up a parenting plan. In 2018, I filed another motion to increase our time together. After a few deliberate delay tactics from my daughter's mother, the judge increased my parenting plan. Then in 2021, I was able to move to Grand Junction, Colorado, and live within 5 miles of my daughter, solely to be closer and more involved in her life. I filed a motion to increase 50-50 custody and told both my daughter Isabella and her mom. Shortly after filing that motion, I have never seen or spoken to my daughter again. It has been over 4 years now. I have never missed a video call, a visitation, or child support payment. On the other hand, her mom was in contempt of court, and the court didn't follow its own court order set in place. Opposing counsel further pulled more delay tactics, further harming my relationship with my daughter, and then the magistrate ended all my visitation and video calls. I hired 2 PREs, a work product review, 2 family therapists, multiple individual therapists, and had an expert review all professional reports, including talking parents, and write a report to prepare to testify. After filing many motions, I was finally able to get into court, and the magistrate decided not to allow my expert report as evidence and wouldn't let her testify to this specific case. The PRE and both family therapists agree that it is in my daughter's best interest that we have a loving relationship that we once had, but the magistrate has silenced me, my expert, my attorneys, and won't follow the family therapist recommendations that the magistrate put in place. I've spent over $300,000, moved to Grand Junction to live close to my daughter, left my family and friends, and have reduced to a child support payment. I pray this bill, SB 26073, stops this from happening immediately so not one more child has to suffer this tragic loss of time with a loving parent and family, and hope the judicial system, the attorneys, and the mental health professionals are all held accountable. Thank you.
All right, thank you. Ms. Jordan, please go ahead.
Thank you, Mr. Chair and members of the Senate Judiciary Committee. My name is Melanie Jordan, and I am testifying on behalf of the Office of Respondent Parents Counsel in support of Senate Bill 73. The ORPC provides high-quality legal representation for parents in crisis who have been separated from their children in dependency and neglect cases. We also have a very small pilot program providing representation to a small number of indigent parents during child welfare investigations prior to a DNN being filed. While Departments of Human Services do not have legal authority to suspend a parent's court-ordered parenting time without a court order, parents are often not aware of their rights and assume that Departments of Human Services do have that authority. Let me give you an example, one involving a father, though I have represented both mothers and fathers in this situation. This particular father's ex-spouse made repeated allegations the father was abusing their child, leading to repeated forensic interviews and long waits, while the department waited for law enforcement to decide how to proceed. During these investigations, the department told the father he could not have his parenting time until further notice. Then they switched to professionally supervised visits, where he was only able to see his child in a small room for 6 months. During this time, the department never sought a court order to restrict his parenting time or opened a dependency neglect case. This happened even though there were never any criminal charges or any findings of child abuse or neglect, findings which have a very low threshold of just a preponderance of the evidence. Without any court orders or a lawyer, he was left to navigate a very complex process and denied substantial time with his child despite no findings of child abuse or neglect. To address your question about why existing law is not sufficient, courts are often reluctant to award makeup time when there is no court order suspending parenting time in the first place, because they view those suspensions as voluntary, even though they are not. There are court processes available both in domestic relations cases and in dependency neglect cases where Departments of Human Services can request changes to parenting time and custody arrangements. These processes require evidence and protect parents' due process rights. They also ensure that there's a court oversight when there is disruption to a child's routine and relationship with their parents. Reports of abuse or neglect should absolutely be taken seriously and investigated when they meet criteria. However, as you've heard, the vast majority of reports of abuse or neglect to the hotline end up being unfounded. Just over a quarter of reports made are investigated, and of those, just over 17% are actually substantiated. Because these investigations are so disruptive to families, it is imperative that we provide protections for parents and children whose relationship are disrupted as a result of unfounded reports. On behalf of the ORPC, I ask for your support of this bill, and I'm happy to answer any questions.
Ms. Jordan, thank you. We'll go to our final witness, then we'll proceed to questions. Ms. Van Gorder, please go ahead. Ma'am, you are on mute. Please check the sound on your end.
Is that better?
Okay, yes, please go ahead.
All right, thank you. Thank you. I'm from Larimer County, and I am in support of this bill. I urge you to be as well.
Sorry, ma'am, can you, I think I can see it on the screen, but for the record, can you please note your name?
Rosemary Van Gorder, Fort Collins.
Very good, thank you. Please go ahead.
Okay. Children don't need rulings. They learn from outcomes. They learn that truth doesn't matter. Accusations carry power. Authority isn't accountable. And love can be taken by force. What kind of society survives teaching its children that lesson? A system that destroys families today, creates broken adults tomorrow. This is generational harm by design. Family law is not broken, it is structurally dangerous. Families have thrived for millennia without family law courts, professionalized conflict, state-enforced parent removal, financial extraction disguised as protection. Children were raised by parents, not court orders. Disputes were resolved, not monetized. Today, the system rewards escalation and punishes cooperation. It tramples due process. It erases constitutional rights. It creates generational trauma. When a legal system benefits from suffering, suffering becomes policy. This isn't reformable at the edges. It requires structural accountability. I believe this bill will do that. It will address noncompliance, which is contempt of court. It will address false allegations and reports that currently have no consequences when made. It is reasonable. It builds in accountability, and it provides incentive to comply. One comment about family civil courts. These courts may make a finding, and believe me, a preponderance of the evidence is not a true finding. Magistrates sit on the benches. They're not judges. And I have to just confirm that the Department of Human Services tends to make findings without full investigations because they're not licensed or certified investigators. So it's problematic. It's not the real deal. I urge you to support this bill. Thank you.
Okay, thank you. Now, committee questions for any witness on Zoom or in the room? All right. Seeing none, thank you all for being with us. Thanks for connecting online. Okay, do we have anyone else apparently in the Zoom waiting room to testify on 73? Okay, and last call for anybody in the room who's not already had a chance to testify. I think that was everybody I had called, but we'll do a final invitation here. Okay, I see a raised hand icon for Judy Atwood. Let's promote her if she's able to testify. And then I saw the following witness online before, Lily Landakusik. I'm not sure if she's still with us. All right, Ms. Atwood, looks like you're getting connected. If you can hear us, feel free to unmute, activate your camera, and please go ahead. Ms. Atwood, feel free to go ahead. Please check the sound on your end.
Can you hear me now?
Yes, please continue.
Okay. Good afternoon, chair members and members of the committee. I had a speech prepared this afternoon. My name is Judy Atwood. I'm here on behalf of Stop the Abuse for Everyone, an organization where we look at current legislation in regards to parent rights. I wanted to address some of the concerns that came up in testimony today. I am a 13-year veteran in the family court system, and I'm here to tell you that it is a very difficult process. And I wanted to address first, in regards to the Colorado findings for screened out maltreatment of calls. Currently in the maltreatment annual report for CDHS, it's 70 to 75% of calls for abuse are screened out by CPS. I also wanted to address 1410-129.5. 1410-129.5 says that a judge may return parenting time if parenting time was withheld. And I wanted to address that because I actually had my parenting time withheld. I had to file a contempt. And in the contempt proceedings, they found that my parenting time was withheld, but they sent us to hearing to discuss how much parenting time I would get back. That hearing cost me over $20,000. And the calculations to me were not addressed appropriately. So I went to the Court of Appeals. That would be 3 appeals that I won in my domestic case. And they found that the calculations for my parenting time paid back were wrongly calculated. This was $30,000 out of pocket to me to get my parenting time back. SB 073 is a guardrail for 1410-129.5. It essentially is telling the judges, right now it's up to judicial discretion, but it's actually giving them a guardrail saying, in the event that there is no findings of abuse, that you have to return that parenting time. And for me, it cost me 3 years to get my parenting time back. And it was out of pocket. So thank you for your time.
All right. Ms. Atwood, thank you. Please stay on the line. Ms. Linda Cusick, please go ahead.
Can you hear me?
Yes, please continue.
Thank you so very much for hearing my testimony about this bill. My name is Lily Landakusik. I'm a licensed marriage and family therapist. I am also the founder of a large counseling agency in Salt Lake City that started in-home. I was the first person who started in-home as a clinical model for families in crises, and I've been in practice for over 30 years. What brought me to this meeting is personal experience and my professional experience, and I just wanted to share my deepest gratitude to be able to share my testimony. I wanted to share in 2 parts, as a professional and as a parent, and I'm going to save the parent part for last because I'll get emotional. I've never done this before, so forgive me for being a little annoying in the waiting room. I didn't know how to join. This bill is very straightforward to me. I'm absolutely in support of it. I think from listening, this is the first time I've come to one of these meetings. I think there's a lot of misinformation about protecting children of abuse and overlapping them, where this, in my experience and my 10 years of working with cases in the family court that have had time taken, this is an urgent issue. It is an epidemic issue. When I heard the amazing testimonies of the people that were talking about suicides, gun violence, drug abuse, access, Snapchat, the predators that are in our children's lives, this bill is keeping children with their safe parent, and that helps stop so many issues that are related to children being successful today. The number one qualitative component of a healthy child is long been accepted as having healthy parents, having them involved, having them get along. As soon as I want you to hear this one point if you don't hear anything else that I say today. As soon as you make it optional that a child does not have to go back to their safe parent, that any person can say you've abused your child, you might go home and your child is gone. And I think there's incredible misinformation about falsified allegations. They are epidemic. What you need to understand is abusers use anything. And if we're protecting against domestic violence, we need to protect against abusers who learn to weaponize the system. And if you don't work in the system, it is rampant right now. The family courts are rampant. You could almost put the family courts in as some of the other predator groups that were spoken about in earlier bills and just fill in family courts and have the same outcome, which is very disturbing. You know, some of the same testimonies of parents saying you trust these people. You know, we're going to people, doctors, lawyers, special masters, guardian ad litems, parental coordinators, reunification therapists, individual therapists, family therapists, trauma therapist, commissioner, judge, mediator. No one can sustain that. Once you have a parent take time from a safe parent, it is too late. It's too late. If you go home tonight and your child's taken, you might get them back, but you'll never be the same. These are parents who are losing their child not for a day, a week, a month. I haven't seen my daughter in anything meaningful for 6 years, and I don't want to talk about my story today. I want to talk about my example as a representative of 22 million voices who've been blocked access to our children. If you pick up a baseball mitt, you might find joy in that. I would break down crying. You might find a tennis racket, a picture of maybe your parent before they passed and how beautiful your kids were there. My daughter wasn't there. My mom and my sister passed last year, and my ex refused any form of supporting her to see my mom. My daughter plays D1 tennis at the University of Utah. My son earned D1 scholarships. They're really successful. I knew I was in an abusive marriage. My son has a different father. We get along great. He lives up the street. I love them. I love his wife. He could come on and share what he saw, that my daughter was taken in broad daylight by weaponizing time taken.
Ma'am, thank you for testifying. We'll see if there are questions at this point. Committee questions of either witness. All right. We're seeing no questions in the room. Thank you for connecting and testifying with us. All right, final call. Do we have anyone else on the Zoom? That was everybody on the list at any rate. All right. Seems like not. Nobody else in the room. All right, we'll close the witness phase, and we will invite Senator Bright back to the table for amendments, if any. Senator, have you amendments you want us to consider for SB 73?
No amendments.
Okay, committee amendments to 73. Seeing none, we'll close the amendment phase. Wrap up comments, Senator Bright.
Thank you, Mr. Chair, members of the committee. You've heard some pretty compelling testimony today, and now you understand why I'm here presenting this bill. I am a child of a split family. I was fortunate to not be involved in a dispute over custody, but I believe I'm an exception rather than the norm. You've heard testimony of how the system has not supported parents when they need it most. These are just a few examples of many that couldn't make it during this workday. Senate Bill 73 is just simply a double check. If there are found no errors in the original case, this bill does not pertain. And I'd like to paraphrase a key component of the bill. The court shall order additional parenting time to compensate a parent or legal custodian who was wrongfully denied court-ordered parenting time if the denial resulted from an investigation by a law enforcement agency, child welfare agency, or County Department of Human Services. If there were fraudulent statements made and brought to the court and a favorable outcome is achieved, time in addition to a successful judgment would be allowed. The premise is simple and compelling. And I would encourage a favorable vote on Senate Bill 73.
Thank you. Committee, any closing comments on 73? Senator Snyder.
Thank you, Mr. Chair, and thank you, Senator, for bringing this. And I want to express my admiration for you for jumping into this very difficult space, something I've been following my whole time in the legislature, and I can honestly say I haven't come up with a great solution yet. It concerns me a little bit that a lot of the testimony we heard was ascribing bad motives to the judges and folks that work really hard, in my opinion, to get these situations right. And what I really can't get over is how does this fit with the standard that we've used in all child cases, which is what's in the best interest of the child. And I understand there are people that are going to hear this and think, I'm not getting it, that the system's corrupt and there's a lot bad stuff going on behind the scenes. I can't support this measure as it makes it mandatory. There's shalls in here. They shall be compensated. I think when a court is hearing both sides, and we heard testimony from a witness who said both sides lie. They both lie on their own behalf to get what they want. And I agree there's real problems in the current system we have, but unfortunately I won't be able to support this bill today. But thank you for your persistence.
Senator Henriksen.
Thank you, Mr. Chair. I do not believe that there is an epidemic of false accusations. I do believe that they occur. I do believe that does happen. And rare cases do need to be accounted for. We have an obligation to not just brush over instances because they occur rarely. We have a responsibility, I think, to get that right. I'm not sure that this gets there, although I appreciate the effort. I think where I get hung up on specifically are the phrases, unless a parent or legal guardian shows good cause as to why an order for additional parent time should not be issued. I think there's a burden shift there that deviates from so much else of the statute that I worry that I really got hung up on that after we had our opening conversation, because I think that has the potential and intended consequence of silencing those who may have valid concerns out of fear. Certainly if there is cause to show that there was an action brought in frivolity, that changes the dynamic, but this shifts the burden of proof, as I see it, to the parent that raises a concern, and I don't want to silence parents or have a chilling effect on parents from raising concerns. And then the other piece is, I really was compelled by the testimony from the advocate from the Victims' Rights Organization about the granting entirety within the scope of the parent who's deemed to have been wrongfully denied. I do worry that could run afoul of the best interests of the child, because there's so many dynamics. If we are to implement a scheme where there is guaranteed for a compensatory parenting time given, the best interest of the child is exactly who that should be. And so I think for those reasons, I'm a no. But it's certainly been an interesting topic to get into, and I appreciate the sponsor for bringing this.
Members, other closing comments? Senator, like our colleague from El Paso County noted, I'm a number of years deep into hearing bills like this. I think no debate that these contentious separations are pretty miserable for everybody involved. You know, I have friends who come from separated parental backgrounds, and I don't think they were near as acrimonious as a lot of what we've heard about tonight. And nonetheless, I know it was hard for them and their families for at least several years, even if things have ended well. I'm not really here to defend the status quo, but I do have to be convinced of the degree of fit of a proposed solution to the problem that has been articulated, even just sitting here, and references to different statutes and extant mechanisms. I heard at least 3 ideas that I'd be happy to chat with you offline about that might be the foundation of other ways to go at this issue. I think the senator from Pueblo has summarized one type of potential problem that could arise as far as overcorrecting. If we were to really interrogate the data out of Colorado-specific human services findings, of course there's a national discussion about this. There's a national discussion about every issue that's important to anybody now, but we have to make policy based on what's going on here. We might find ways to frame a little bit more nuance out of that. It does speak pretty loudly to me this afternoon that 3 of the 4 major survivor organizations for domestic violence, for sex assault, for vindication of VRA prerogatives in general, are all opposed. Some of them took pains to communicate that to me previous to today, as well as sitting here this afternoon. These are organizations that don't even all agree on all issues that come before judiciary, and interestingly, they didn't all agree on the bill that we debated Monday, but they all seem to be aligned here, and I have to weight that pretty heavily in how I think about this. So I don't think I can get to supporting today, but there's work to do in family courts. It sounds like some folks have maybe had okay experiences with PREs here. If I heard that right, I'm actually glad to hear that, because I'm afraid, based on what I've heard in 10 years, that's more the exception than the rule. There are some incentive problems in the system. This legislature has done some work to curtail those. I think there's more work to do. At any rate, thank you for bringing the bill to us today. Members, the motion for 73 would be to the Committee of the Whole. Senator Frizzell.
Thank you, Mr. Chair. I move Senate Bill 26073 to the Committee of the Whole.
Okay, proper motion. Ms. Jensen, please call the roll.
Senators Carson,
Yes.
Frizzell,
Aye.
Henriksen,
No.
Snyder,
No.
Wallace,
No.
Roberts.
No.
Mr. Chair.
Respectfully, no. All right, the vote is 2 to 5. Members, is there another motion? Mr. Vice Chair.
Thank you, Mr. Chair. I move that Senate Bill 73 be postponed indefinitely by the use of a reverse roll call.
All right, seeing no objection, SB 73 will PI on reverse roll call. All right, Senator, thank you. Okay.